I am a living man, capital E, lowercase RIC, of the capital M, lowercase ARTIN family. One of the people, sovereign, not a legal fiction corporate entity defendant with a name similar to mine, and here by special appearance, to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it
So I
just
already
standby?
made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's how I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Yeah, that's it. That's how I was going to make the motion to dismiss him if you if he's if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, yeah. So as I said before, so I'm not going to be accepting any attorneys who's going to fraudulently assume I'm a defendant, and which would then.
This courtroom turns into a law school fever dream the second Eric Martin speaks. He's not just denying guilt, he's denying reality. When someone introduces themselves as a living man, not the corporate entity, you already know it's about to get wild.
I'm not. As I said before,
Sir, you got 5 minutes to make your arguments, and you can spend them however you want to.
all right, yeah. Like I said before, I'm a living man. So as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent, and it's also under. There's no consent under the Declaration of Independence of. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions though for the prosecutor. That's
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not. There's no standing, shouldn't move forward. But so, what's your ruling on that?
Your motion is denied as to jurisdiction and standing.
Sovereign citizen defendants love twisting constitutional words like they're magic spells. Consent, living man, jurisdiction. He strings them together hoping the judge evaporates. But here's the truth. Courts don't run on imagination. You can't reject jurisdiction because you don't feel governed.
Is the court ready for the people's response run?
I don't know if he's done with his motion.
Oh, I'm sorry.
Yes, I'm trying to make.
Well, the police. I wanted to question the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination. Move to dismiss the case based on that because he made me give my ID. But my memory was it's a little I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which was under threat and duress. And even if he didn't say that, which I don't remember, which, like I said, I need to have his body cam and all that. I want that. I want to be able to review that now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. Like I said, it violates my self-incrimination right that I'm being made to give my supposed name, government name, anyways. It ain't really my name, but a government name has been given. Violates self-incrimination, and then it's used against me to prosecute. So it violates self-incrimination. Yeah. Move to dismiss based on that too. And like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So
Now he flips the script, calls himself the victim, and demands the prosecutor charge the officer who stopped him. That's the moment you realize he truly believes he's discovered a secret legal cheat code, the kind YouTube conspiracies promise, but reality never honors.
oh, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you, for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so
As to your motion to recuse, that is denied.
based on what reasons? Conflict of interest is my reason. That's why I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed, that's the grounds of my demand for dismissal.
Okay.
Filing a federal lawsuit against the judge mid-hearing is peak sovereign behavior. He thinks mailing a few papers automatically strips the court of power. Spoiler, it doesn't. It just makes the judge's patience legendary.
No case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, you know. And then, okay, so because they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, oh, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance. So I was all within my right under that federal statute and the U.S. Supreme Court case law that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions it specifically, and I'm gonna mention right here, Volume 44, Supreme Court Reporter, page 259. Streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. As they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stop and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also a federal crime, which I'm gonna be contacting the FBI about. I already tried once. I gotta call him back. So, well, I'm gonna see if you got my if you're gonna, I would like to just reiterate my the demands for dismissal already made, or if you want to call them motions, but like I said, I like using the word demand because I don't agree to no unlawful presumptions that because I understand the legalese.
The right to travel argument never dies. Every year someone walks into court quoting random Supreme Court lines from 1900, convinced driver's licenses are optional. It's the flat earth of traffic law, and judges have heard it 1,000 times.
This case began to be pending in this court. And I'll just briefly address the as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other two. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendant specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And most, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh, yes, Penhallow versus Doan's Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. It's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware. That quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows that does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse.
Watch how the prosecutor dismantles him calmly, point by point. She exposes that his so-called Penhallow case doesn't even exist. It's incredible. She basically tells him, you copy-pasted fake law off Google. This is the quiet part where logic finally swings back.
I missed, and then I can respond one by one. Okay.
That's not how this is gonna work, sir.
That's
I
not
think
how.
to understand here, you
I have the right to that. What are you talking
you're
about?
not controlling this courtroom, sir. That's not how this.
I'm speaking about what I have a right to do. I have a right to respond back. So
You're
All right.
gonna get 5 minutes and I'm gonna be done. So that is your opportunity. And after that, I'm gonna make my rulings. You got
Well-
5 minutes. I'm actually setting a timer.
all right. Again, I object to that again as being violates my due process right to the First Amendment. It's not supposed to be regulated by a certain time limit. My First Amendment right to say what I got to say, based on an arbitrary, unfair time limit.
Sir, in a minute, you're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You have.
Okay, I want to object to that too, though, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant. You need to actually do what is requested of you, and I'm giving you an opportunity to make your argument.
When Martin claims a First Amendment right to argue forever, the judge warns contempt. He doubles down, saying there's no First Amendment in this courtroom. And he's right, sort of. Courtrooms aren't YouTube comment sections. Free speech stops where procedure starts.
Has already been addressed through the court regarding the fact that the court doesn't do that. Any He also filed lawsuits against individuals. Those were also rejected by this court as improper. And those, there's nothing to really address about that. It's already been decided. His motion to dismiss is denied. Despite his understanding of the law, and I'm not certain which law school he went to, summary disposition does not apply to criminal cases and is denied. And same is true for default in criminal cases. That is also denied. Jurisdiction is with this court, as I've ruled before, and I will not be addressing this issue again. The motion to dismiss is denied. There was one point that he did make with respect to due process that is going to compel where we go with this, to question officers except for in a trial. However, he is entitled to discovery in this case. And he mentioned that he did not receive a copy of the video, if there is a video, or if there's body cam, he's making a demand for that. And he is entitled to have a copy of any body cam that exists in this case and a copy of any police reports that exist in this case. So those items need to be turned over to the defendant so that he can properly prepare for any trial. And trial right now is scheduled for 1 week, so I don't think it would give him a proper opportunity to prepare. I will remove this from the trial docket for this upcoming week to and there is one place in which criminal cases does have a demand, and that is a demand for discovery. So I think he is making that demand for discovery, and I am going to require the.
I think the issue was the standby counsel and him rejecting representation. So normally this is brought to the PD's office, but since I think it's been reaffirmed today that I'll figure it out. We'll get it done somehow.
What do you have an email, or are you just gonna, Mr. Martin, are you requesting to have the documentation sent to you via mail or email? How do you plan to receive it, sir?
To refer to me as Mr. I understand that's another one of the term Mr. is another one of the what's the words I'm looking for? I forget what it's called here.
All right.
And then, finally, a dose of justice. The judge keeps her cool, orders the state to give him body cam evidence, and still denies every fantasy motion. It's balance. Respect the defendant's rights, but don't indulge delusion.
Right, you can, you would like to figure it out to give him that documentation, and I'm going to give you a new
Legalese term. That's the word I look for. The Mr. is a legalese term that's fraudulently assuming I'm a defendant and all that. But anyway, so
Yes,
my
Your Honor, while you look for that date, I will just state on the record, if Mr. Martin, Eric Martin, living man, the individual sitting here before me today speaking, if you would like discovery, I would highly suggest that you give the court an email address or some method by which we can deliver that discovery to you, because I'm not trying to keep it from you, but if you don't help me to help you, I can't get it to you either.
I'm gonna give them my address, and I'd rather do it through my physical address here at the home. I just wanted to object to the term first. That's all. Before I forgot, or you guys keep going on. Don't let me do it. But same address I've been sending my demands to and all that, my paperwork. Taylor City, Michigan.
Whoa. I'm talking over because this is live. You don't want everybody in the world to know your address, sir.
Well, I'm not worried about it, but okay. I mean,
okay.
Your
One
Honor,
moment.
we have the information. We can send it over to Ms. McDuffie if Mr. Martin would so allow.
but I don't have a problem with this.
This case shows how misinformation online can reshape someone's entire identity. Eric Martin didn't just lose emotion. He lost touch with the system that could have helped him. Sovereign ideology promises freedom but delivers isolation. In the end, the only law that matters is the one that exists, not the one you imagine.